Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and the topic for today's video is how to evict an ex-employee or caregiver that refuses to leave after being fired. Please like, subscribe, and hit the notification bell because it helps this channel grow. Also, leave a comment with any questions that you would like to be considered for the Ask a Real Estate Attorney series. Employers sometimes provide their employees or caregivers housing, and when they fire their caregiver or employee, they sometimes refuse to leave. If this happens in Maryland, then the employer will have to go to the local district court in order to evict their former employee or caregiver. There are three possible causes of action to use in this situation: wrongful detainer, tenant holding over, or breach of lease. I think the answer, which of these options is appropriate, depends on the legal relationship status between the parties, whether it's a landlord-tenant relationship or a licensor-licensee relationship. A tenant has a lease, possessor interest in the property. A licensee has a license to use the property, at least until the license is revoked. The ramifications of this is that if the employee or caregiver is a tenant, then they have to receive a minimum of a 60-day notice of non-renewal from their landlord if the lease is month to month or year to year. If they have not left when the notice expires, then a holdover action can be filed against them. In the alternative, a breach of lease action can also be used to evict the former employee or caregiver if they're in breach of the lease. This generally requires a 30-day notice, but a 14 notice can be used in an emergency situation. If they're not a tenant, but a licensee, then they just have to be asked to leave. If they refuse to leave, then they become squatters. And wrongful detainer actions are used to evict squatters, more specifically, licensees that refuse to leave in this particular case. Whenever I draft employer-employee housing agreements, I like to use the licensee language and make it clear that the licensee has to leave when their employment ends. That said, many employers offer their employees lease agreements with similar language. The potential downside of using a license instead of a lease agreement is that it's possible for a judge to construe that the agreement is a lease, not a license. For that reason, I think it's a good idea to have the license drafted by an attorney to mitigate the risk. I hope you enjoyed this video, and now hopefully you have a good understanding of how to evict former employees or caregivers that refuse to leave. That is my contact information on the screen. If you need an attorney, you can feel free to contact me. Thanks for watching. Take care.